friends. Namaste. It's another Saturday, India time, 8 p.m., and we are back with legal words of wisdom, Nyay Gyan Ganga. And today is our eighth episode in our Saturday series. And as you all know, we have Dr. Subramanian Swamy and Dr. Venkat Iyer to discuss a new topic in today's program. Today we'll be talking about criminal law and what everyone needs to know about it. Most people are frightened of criminal law. This area of law is quite complex and it can have serious consequences for those who get entangled in it. What are the basic principles of criminal law? How are offenses created and applied? What are the various stages through which a criminal case passes? Do those accused of crime have any rights? What about the victims of crime? Can criminal cases be settled like civil cases? These are some of the issues that will be discussed in today's episode by Dr. Venkat Iyer. As you all know, Dr. Venkat Iyer is a barrister, mediator, and legal academic based in the United Kingdom. He was originally at the Indian bar and practiced in Mumbai and India, and thereafter he has settled abroad and has been associated with the legal world, the academic world connected with laws, and has been associated with our program to spread legal knowledge for the common man. And with that, we have Dr. Subramanian Swamy, our patron, host, and I would say the president of Virat Hindustan Sangam on our weekly Saturday show. So I thank our co-host Ramesh Swamy and our team members, the technical team members led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Swaminathan, Tejas, and Rakesh from Bangalore for their technical support for putting this program together. So with these opening remarks on our today's topic, criminal law and what everyone needs to know about it, it's over to Dr. Swamy for his opening remarks, and then Dr. Venkat Iyer will have a detailed discussion on the topic today. Over to Dr. Swamy.
Thank you very much. Venkat Iyer today will be dealing with the concept of the criminal law, how it's put into motion, what are the steps, and what is the process of reaching a conviction for a person who's committed a crime. So I would urge Venkat Iyer explain to us the importance of FIR. And then FIR is called the first information report. Is there something called a final information report? At what stage is a person who is accused in crime taken into custody? Are there categories of crimes, cognizable, non-cognizable, and so on? So there a great deal of intricacies in this field, and it is something vital for everyone to know. Many people get nervous if some policeman visits their house. They should know what their rights are, and how to deal with a policeman who comes perhaps with the motive to collect some bribe or something, how to answer him, how to meet a situation. And the dependence on the lawyer should be on the last, as a last resort. I would urge every educated person to learn enough law that they can defend themselves. They can argue in the case themselves rather than depending on lawyers. No offense meant to Venkat, but the fact is that more and more people should feel empowered by the law, and that is what I would like to see the final objective. There is a provision in the criminal law where an individual can initiate criminal action. I'm sure that Venkat will be happy to tell you, and then I will add in my 2 bits towards the end. Over to you, Venkat.
Thank you, Swamy. I have to start this week's lecture with an admission, and it is that I'm going to deal with a subject over which I have at best a shaky grasp. The subject is, of course, criminal law, as flagged up by both yourself and Jagdish. And it is, alas, an area of law in which I have never practiced except in a peripheral way. So, what I'm going to say is based almost entirely on what I've read and what I've heard from other sources. I apologize in advance for any inadvertent errors or omissions, and I'll be more than happy to stand corrected either by my fellow panelists or by you, the viewers. The way I plan to proceed is by first telling you about some broad principles of criminal law. These principles are important in understanding how criminal law can protect people's rights and societal interests. They are equally important in understanding how a fair balance can be struck between the rights of those affected by crime, that is, the victims, and the rights of those charged or suspected of crimes. Um, I'll then go on to talk about the procedure that is followed in applying criminal law, how those crimes are reported, how they're investigated, what happens in a criminal trial, what are the safeguards available to an accused person, and how the courts arrive at their verdicts. If I have the time, I'll tell you about the merits and demerits of the jury system, which is used in many countries, including the UK, but which was abolished in India nearly half a century ago. I bring this up because one of the viewers of this program specifically raised it the other day. I first want to make a general point, which I think is quite important. It has to do with the fact that under Indian law, people cannot be charged with or punished for any offense that is not contained in written law, that is, law made by Parliament. Criminal law is one area where judges cannot use their common law powers to create offenses. Unlike, say, England, India has a comprehensive code of offenses called the Indian Penal Code. This lists all the offenses that are punishable, although it is supplemented by other laws which create subject specific offenses. For example, company law, under which certain defaults or certain acts relating to the running of companies can lead to punishment. But judges can strike down laws if they offend against any rights constituted and guaranteed by the Constitution. So, for example, the Supreme Court in 1983, in a case called Mitu and Punjab, struck down Section 303 of the IPC, which had said that where a person was already undergoing a sentence of life imprisonment, and if he committed murder, then he had to be sentenced to death. This, the judges said, was violative of the right to life and personal liberty, that is Article 21. Judges can also read down legal provisions. And this happened in relation, for example, to Section 377 of the IPC, the section which had prohibited carnal relations against the law of nature, that is, homosexuality. The court held in the case of Navtej Singh Johar and the Union of India in 2018 that where such acts are committed in private between consenting adults, they would not be deemed to be offenses. The other general point that needs to be made at the outset is that the main objective of criminal law is to punish the wrongdoer. Unlike civil law, where the objective is to compensate the victim of a wrong. It is true that a criminal court often asks a wrongdoer to pay a sum of money, but that payment usually does not go to the victim of the wrong, of the crime, but it goes to the state or to the government, and that is called a fine, whereas any compensation awarded to the victim of a wrong is called damages. Now, there are slight exceptions to this general rule, and it is possible for a criminal court to order a payment to be made to the victim of a crime, but that would be fairly rare. I've already told you in one of my earlier episodes that criminal law and civil law are not mutually exclusive. In other words, it is possible for the same incident to lead to both a criminal case and a civil case, though those cases will be heard by different courts, and neither court will be influenced by the decision of the other. In simple terms, criminal law and civil law have their respective domains. A third general point worth noting is that criminal law needs to be applied with precision. This means, among other things, that when someone is accused of an offense, he or she should be charged only with that offense or those offenses which clearly cover his or her actions. It also means that offenses, as prescribed by the law, have to be construed strictly. It's not open to the police or to a judge to extend the definition of any offense or to apply it loosely by analogy. There is a reason why criminal law makes some very fine and important distinctions in the definition of offenses. To give you a simple example, most of the time we assume that when someone is hit by another person, he's assaulted. Actually, assault is the act which precedes the application of force. It is any act which causes the victim to fear bodily harm, whereas the act which causes the actual harm is called battery. Similarly, the difference between careless driving and dangerous driving, and so on and so forth. The law also distinguishes between committing an offense, attempting to commit an offense, abetting an offense, and conspiring to commit an offense. People will have to be charged with regard to the strict meaning of those terms. This is not just semantics, it has profound practical implications in terms, for instance, of the punishment that can result. It goes without saying that there must be a clear connection between the action complained of and the injury or the harm suffered. In other words, the injury should have been the direct and inevitable result of the alleged offense, failing which the case will be thrown out of court for lack of what lawyers call causality. Do remember that omissions can also result in criminal liability. A simple example is that if you fail to file your income tax return, or if you fail to feed your children, the law may require you to face criminal consequences. Another important principle is that if there's any doubt about the guilt of an accused person, then the benefit of that doubt should be given to him. This may sound a bit unfair to some people, but it is connected with the standard of proof that is required for crimes, namely beyond reasonable doubt, about which I spoke in an earlier episode. A related maxim, which you will hear about from time to time, is better to let 10 guilty persons escape than that one innocent person should suffer. Something which is attributed to the famous English jurist William Blackstone. In practice, of course, that principle has been exploited by clever lawyers to find loopholes or to indulge in legal nitpicking to find a way out for their clients. Related to the standard of proof is the concept of burden of proof. Now, generally speaking, the burden of proving that an accused person has committed an offense is on the people bringing the case, namely the prosecution. This is why it is said everyone is innocent until proven guilty. But there are some exceptions to the rule on burden of proof. Most notably, recent years have seen many countries pass laws which reverse the burden of proof in certain circumstances, for example, in relation to terrorist offenses. Very importantly, criminal law cannot be applied retrospectively. What I mean by that is that you cannot punish someone for something they did if their action was not an offense when they did it. In India, this principle is laid down in the Constitution itself, in Article 20, which says that no one can be given a punishment which is heavier than the law had prescribed at the time of the offense, in addition to saying that law cannot be applied retrospectively in the criminal arena. While I'm on Article 20, I should point out two other principles. First, that no one can be tried for the same offense twice or more. And secondly, that no one can be compelled to be a witness against himself. The other thing to note about criminal law in India is that it is possible for offenses to be made applicable to only certain parts of the country and not to other parts. This is because criminal law and procedure are matters included in the concurrent list over which both the central and state governments have jurisdiction. In one of my earlier lectures, I explained the implications of something being in the union list or state list or concurrent list, and I shall therefore refrain from saying more on that issue now. One of the other features of criminal law is that, generally speaking, there are two things that are needed to constitute an offense. The first is the act itself, say wounding someone, and the second is the intention, that is the mental element which accompanies the act. Now, they are in legal speak called actus reus and mens rea respectively. So to take a simple example, if you end up hurting someone either accidentally or in self-defense, then you cannot be held guilty of wounding or causing hurt or whatever is the applicable offense under the IPC. This area is actually quite a complex one, and in practice, the situation may not be quite as simple. The law makes clear and sharp distinctions between such things as knowingly, purposely, recklessly, negligently, etc. But there are certain offenses which are called strict liability offenses. What this means is that when someone is charged with one of these offenses, the prosecution need not prove that they did what they did with intent. Examples would include waging war, kidnapping, counterfeiting a coin. In those cases, the law recognizes that the acts are so harmful to society that it is necessary to punish those responsible without insisting on proof of intention. Also, that the acts are of such a character that it can be presumed that those carrying them out had intended the undesirable consequences. The principle of strict liability is also, of course, well known in civil law. For example, the consequences of keeping anything dangerous on one's land which can injure others. I want to tell you at this stage about the difference between substantive criminal law and procedural criminal law. Perhaps the easiest way I can illustrate this difference is to talk about murder. In law, murder means the intentional killing of one person by another. Now, under what circumstances an act becomes murder is explained by the IPC, which is therefore substantive law. But how a murder case has to be proceeded with, what steps need to be taken to bring the matter to court, what are the rights and protections available to a person accused of murder, and so on and so forth, are laid down in a law called the Criminal Procedure Code, which is the procedural law. Now, both these laws are essential to run the criminal justice system. As an interesting aside, I need to tell you that there are certain general defenses provided in the Indian Penal Code. What this means is that simply because you are accused of an offense does not mean that you will be convicted for it. You can argue in court that you deserve to be let off on account of one or more defenses that the law provides for. And these defenses are categorized under two broad heads: excusable acts and justifiable acts. So, if what you did was done accidentally, or while you were insane, or while you were intoxicated, or while you were under the age of 7, then you will be excused from criminal liability. The law has certain safeguards to prevent misuse of these provisions. For example, that only involuntary intoxication will qualify for the defense. Which reminds me, there was at least one country where the law on intoxication was particularly harsh, namely the former Soviet Union. There, the criminal justice system not only did not provide that those committing offenses while intoxicated could be excused, but actually made intoxication an aggravating factor. Also, if you did something out of necessity or duress, or with the consent of the party who was harmed, again, you'll be let off. This will also apply incidentally to a situation where, say, a judge punishes someone to life imprisonment after misunderstanding or misapplying the law, and the person spends a couple of years in prison before being acquitted by a higher court. The judge cannot be charged with unlawful imprisonment because what he did was done in the course of his official duties and done in good faith, even if it was a wrong act. Another example would be, say, if a doctor told the wife of a patient that her husband was suffering from a fatal disease, and upon hearing this, the wife had a heart attack and died. The doctor cannot be charged with any offense relating to her death as long as he had acted in good faith, because he had a duty to communicate his diagnosis to the wife and he had simply discharged that duty. I mentioned consent. An example of consent as a defense will be when someone who agrees consciously and voluntarily to engage in a boxing match, but then complains that he suffered injury at the hands of his opponent, for which the opponent should be punished. Such a complaint will be thrown out because the injured boxer had implicitly consented to any injuries that may arise in a boxing match, provided, of course, that the rules had been followed. Returning to the Indian Penal Code, we see that the offenses there can be grouped under a few heads. These include, first of all, offenses against the state, such as waging war or treason or counterfeiting coins. Secondly, offenses against state agencies or instrumentalities of government, such as bribing a public servant or obstructing a public servant in the discharge of his duties, or perjury. Thirdly, offenses against the public, such as rioting or unlawful assembly or criminal trespass, and in the COVID era, violation of quarantine rules. Fourthly, offenses against the person, such as murder or rash driving or kidnapping or rape. Fifthly, offenses against property, such as theft or robbery, criminal breach of trust, and so on. And other offenses, for example, against the institution of marriage, including now triple talaq. Let me now turn to the process of criminal law and to the nuts and bolts of how it operates. I'm going to skip citing the section numbers from the relevant law. In this case, it will be the Code of Criminal Procedure, mainly to save time, but also, frankly, because I cannot remember those details. and I don't have a copy of the CRPC in front of me. In any case, I'm sure Swamy will be able to supply the missing information in a flash, given that he has such things on his fingertips. I'll first lay out a few terms which are useful to know. There are two broad types of offenses, to which actually Swamy has already made reference: cognizable and non-cognizable. Cognizable offenses are those offenses in respect of which a police officer can, on receipt of sufficient information, proceed to arrest a suspect on his own initiative. But for non-cognizable offenses, the police would need a warrant from a magistrate to carry out an arrest. As you can imagine, cognizable offenses are more serious than non-cognizable ones. If you report a non-cognizable offense, the police will not be able to proceed with its investigation without permission from a magistrate. The way the system works is that when an offense is reported to the police, usually it will be a police officer, then he has to prepare a first information report called an FIR. If it is in relation to a non-cognizable offense, then the FIR will only be prepared after permission is given by a magistrate. Alternatively, the informant can approach a magistrate's court directly, in which case a complaint will be registered there. After the case is investigated by the police, a report is made to the relevant magistrate's court for prosecution. If the case arose out of a FIR, then the prosecution is carried out by the state. If it arose out of a complaint, then the prosecution is carried out by the complainant, which is a private party. When a magistrate takes cognizance, he issues either a summons or a warrant to enforce the attendance of the accused person, also sometimes witnesses, and warrants are issued in more serious cases, summons in less serious ones. Incidentally, there are some safeguards against arbitrary or high-handed arrests. For example, women can only be arrested during daylight hours, not between dusk and dawn. Also, only reasonable and necessary force can be used in carrying out arrests. Incidentally, there are judgments of the higher courts which insist that the police shall not refuse to register an FIR where necessary information is given and where the correct police station has been approached. Also, every person who lodges an FIR is entitled to a copy of it. Jurisdiction is another important issue which sometimes creates problems. Generally speaking, only the police station or the court within whose territorial limits an offense has been committed has jurisdiction to deal with the case. Where a person approaches the wrong police station, there is a duty on the part of those manning it to assist him in going to the correct one. Though this also, I'm told, does not always happen. Often there are disputes about jurisdiction. You'll recall something like that happening in the very recent case of Sushant Singh Rajput. I shall firmly resist the temptation to say anything more about that case for the simple reason that I do not know much about it. An interesting practical question that arises is, can an offense be reported at any time, however late? And the answer is, generally speaking, no, because the law prescribes what is called a period of limitation, a deadline, beyond which proceedings cannot be launched. This is quite a complex area of the law because there are different limitation periods prescribed for different offenses, depending on their severity and depending on the nature of the punishment awardable. To give you a simple example, if the offense can only lead to a fine, the complaint has to be lodged within 6 months of the offense happening. The reason for limitation periods is to ensure that people act promptly in bringing their grievances to the police or other authorities, and also to ensure that potential defendants are not subjected to harassment indefinitely. But to provide for genuine situations where a complaint could not have been made quickly, the law allows the courts to condone delays as long as strong justifications are provided for the delay. Uh, this issue became relevant in many cases of sexual harassment that have been coming up recently in the context of the so-called Me Too movement. Another feature of criminal law in India is that certain offenses can be compounded. What this means is that if the victim of a crime and the accused person come to a settlement before the case is decided, the court will allow for the withdrawal of the case. At one level, the arrangement sounds reasonable, purely from a practical point of view, the point of view of reducing arrears, but it can also be seen as worrying from the point of view of the sanctity of administration of justice, because an overarching basis for criminal law is that any offense is as much an affront to society as it is injurious to individuals. For that reason, compounding of offenses is not allowed in most countries and is viewed with abhorrence. Of course, Indian law does not allow for cases involving serious offenses to be compounded, for example, murder, but only less serious ones like causing hurt or criminal trespass or adultery before it ceased to be an offense. This issue came up just a week or so ago when the court hearing a criminal defamation case filed by the journalist and former junior minister M.J. Akbar against an ex-colleague called Priya Ramani asked the parties if they wanted to compound the case. Now, what about punishments under the IPC? There is a range of them, starting with a fine and going right up to the death sentence. In between, you have imprisonment either for life or for defined shorter periods, and this can be either rigorous or simple. It is also possible for the courts to order the forfeiture of property. You will sometimes hear about concurrent sentences. What does this mean? It means that if a person is given 2 or more sentences, say 5 years for a certain offense and 5 years for another offense, tried at the same time, then he only needs to spend a total of 5 years in jail. But if the sentences are consecutive, then he has to spend 10 years in jail. It is, of course, possible for a person to be released from prison under certain circumstances, usually temporarily. If the release happens before or during the trial, the process is called bail. If it happens after conviction, it is called parole or furlough. Parole is granted on specific grounds, for example, to attend the funeral of the convict's parent and similar circumstances, but furlough is granted without any reason being cited, essentially just to allow the prisoner a break in his incarceration, especially if he is serving a long term. A huge amount of case law has developed over the years on this subject. There are just a few other points I want to address before I wind up. The general principle that ignorance of the law is no excuse applies as much to criminal law as it does to civil law. The IPC specifically allows for the defense of ignorance of a fact, subject to certain conditions, one of which is that there should be good faith on the part of the person invoking this defense. Good faith is an important concept which has application in various areas of the law. In simple terms, it means acting with utmost probity and fairness, not being deceitful, being honest, and so on and so forth. But the IPC defines it in a slightly roundabout manner, using the phrase due care and attention as the key ingredient of good faith. About jury trials, it is an interesting but academic question because I cannot foresee the possibility of juries being brought back in India. But we do have them in the UK, and most people will say that there are both merits and demerits in the jury system. Incidentally, there is something very similar to a jury still being used in Bombay, Calcutta, and Madras in the High Courts, but for a very limited purpose, namely to decide contested Parsi matrimonial matters. That system has also been under assault in recent times, but it has just about survived. More generally, I'll make 2 points about juries. With the advent of the internet, new challenges are being presented because we've had a growing number of cases in the UK where members of the jury have been seen looking up information about defendants on the internet, including about their previous criminal records, which of course is very detrimental to the sanctity of the system. Secondly, the presence or absence of juries in criminal trials makes a huge difference to the rules on sub judice, about which, for other reasons, there's been a lot of discussion in India in the recent past. I'm afraid I don't have the time to say more about this fascinating subject, including, of course, about stories on jury misconduct, of which there are many, but perhaps we can discuss this topic on another occasion. The final thought I want to leave you with about criminal law goes back to a point I've been making repeatedly in the course of these episodes, and that is that unless you have a fair, impartial, competent, independent, well resourced judiciary, and also investigative agencies, including the police, the CBI, the NIA, etc., the system is unlikely to be effective. Merely tinkering with the law is not enough, though I recognize that law reforms are sometimes necessary. The bigger challenge is both structural and at the level of those appointed to run the institutions. And that requires a huge amount of political will. Thank you.
Good. Thanks very much. I will start. I have some clarifications to seek from you. One is we'll start with the sub judice. Once in the Supreme Court, when I was arguing the 2G spectrum scam case, and every session that was over in the Supreme Court, I would walk out, and then the lawn of the Supreme Court, the press would be in large numbers. I would brief them what was said, what's spoken, so on. So P.P. Rao moved a petition on sub judice, saying that it should be punished for sub judice. And the court asked me, what do you have to say? I said, P.P. Rao is still living in the past. Sub judice was originally invented to prevent the jury from being influenced. Jury usually are selected from ordinary people, sometimes from the telephone directory. And if a prominent person goes to the media and explains what this whole crime is about, etc., then the jury could be influenced. So therefore, because this is here's a great luminary who's talking about these things, and maybe it is right, so he may decide. After all, the jury system means by majority you decide whether they're guilty or not. So therefore, once the jury system was abolished, and incidentally, the jury system was abolished because in that case of
Nanavati, yep.
Yes, the media played such havoc that even though he said in court, I did kill him, the the jury acquitted him. So moved by his plight that his wife was having extramarital affairs. So, although he killed his wife, he killed the lover of his wife and admitted to it, the jury still acquitted him. So, after that, we abolished it. So, today there's no such thing as sub judice, but the old habits die hard. Everywhere I keep hearing sub judice, sub judice, sub judice. So could you clarify on that? What is the status of sub judice in a country which doesn't have a jury?
The position that you have outlined is absolutely the correct position, because the main purpose in having the sub judice rule in countries which have a jury system is to prevent the jury from accessing material relating to an accused person's previous convictions,
That's right.
or about any prejudicial matter that may be discussed in the media. Now, the sub judice rule, first of all, therefore, only applied when there is a jury hearing a case. And secondly, that it would cease to apply after the conviction has been made.
Right.
And, for example, if there was an appeal in the same case, it wouldn't. The sub judice rule will not apply in the same way in the appeal. People can discuss freely because the conviction is already over, and in an appeal, no jury is involved. So the absence or presence of a jury is very, very important, and even there, it's for a limited purpose. It is not as if because there is a jury hearing a case that nothing about the case can be discussed. Far from it. In fact, there are so many cases in England where juries still hear cases of a serious nature in what we call the Crown Court, where there's extensive discussion of the case in newspapers or on the media. So there is absolutely no justification for adopting that attitude that something is sub judice and therefore we shouldn't speak anything about it. Unfortunately, of course, first of all, there's a lot of ignorance on this subject in India, but secondly, it is also being used by people who know better as a smokescreen to prevent
That's
any
right.
discussion. So
In
I would
the case
actually very strongly campaign for that attitude to be
Yes,
erased in India.
that's right. There's no such thing as sub judice in Indian criminal law. Now,
Except, sorry, there's one other small thing. It is, of course, possible in certain circumstances for the sub judice rule to exist, even in a system without jury, and that is where there are attempts to prejudge the outcome of a case in a manner that is going to put intolerable pressure on a judge. The understanding is that a judge, by his training, can sniff out any such attempts, and he will actually be oblivious to such attempts. But there might be some occasions when, for example, a huge campaign, a concerted campaign is used, either to let someone off or to have them convicted. Then, in those circumstances, there might be a justification for application of the sub judice rule.
well, that's an ad hoc
Yep.
arrangement.
And also
It's not-
exceptional.
Yeah, exceptional.
Yeah.
Well, supposing I said a judge deciding against me that this judge doesn't understand the law, is that
Yep.
contempt?
According to
Is
me,
that-
no. In fact, I have been reserving a lot of ammunition to talk on contempt, not next
Okay.
week, but the week after. And I'll
sure.
give you example after example where even worse
Will
things have
be
been said
paid.
about a judge. Yeah.
Okay.
So, for example,
But
call
if I said the judge took the money and then
Yeah.
gave the judgment, then that's criminal contempt.
correct, because what you're talking about is a motive, not
Motive,
any discussion of the
not on the law.
of the competence of the judge. So, if there have been quite a few cases, not in India but outside, where a judge has been called an idiot, actually in print, and nothing has been done because ultimately that shows that the judges have broad shoulders, and that's how it should be. Ultimately, it's also for the appeal court to correct a judge who has acted
Yes.
wrongly.
That's right. Correct. Now, you mentioned Sushant's case.
Hmm.
I'm asking you a question here. Sushant, when he was discovered, whether he was murdered, whether it was suicide and all, I'm not going into that. But something which is in the IPC, some law, some crime has taken place according to the IPC. And immediately the Bombay police is informed. Was it by law required, or by Supreme Court case laws required, that having received a grave incident such as murder or suicide, they must register an FIR immediately?
Now, I'm not 100% sure if the system would operate. When you say immediately, you mean
Upon receipt of
without waiting for any further
yes, evidence.
further information. I would say that if it's a case of death, whether
Yes.
accidental or suicidal or murder, there is a duty to definitely lodge, not lodge, to prepare an FIR, because they have received information. Now, if it turns out that the the investigation is going to lead to a dead end, that's a different matter. But there's definitely a requirement.
A final report.
Yeah, that will be the outcome of the case. But yes,
First information report and final information report.
Yeah, although that particular phrase is not used in the penal code.
I know that.
Yeah, but yes, definitely there will be an obligation when information about a murder has been, or a death has been
unnatural death.
Death under suspicious circumstances.
Yes, unnatural death.
Yeah.
All right. If police refuse to do that, even after 70 days, or maybe Sushant's unnatural death was discovered on 14th June. Till today, they have not registered an FIR.
Right. I would say in that case, if you had a decent, effective, operational justice system, you could go to the High Court and seek a writ of mandamus to compel the police to record first information report.
Yeah. Of course, now it's become academic because the CBI has been brought in and they have inherited an FIR registered in Patna.
Yes.
And so that matter is closed. But there could be dereliction of duty. Is there something like that in criminal law?
Yeah. Yes. Absolutely. Yeah. Okay. And in any case, these are matters where if there is a mandatory requirement of the law, then if that requirement is not
requirement according to case law, there are a number of Supreme Court judgements which say the police cannot evaluate the information. If you have received an information, you have to immediately put out an FIR.
Yeah.
And the Bombay police didn't do it. I'm surprised that nobody thought. I mean, I had enough burden doing so many cases. I can't be running after going to Bombay and going on that too when Corona is on and file a case in the Bombay High Court and so on.
Yeah.
But I am saying, look at the extent of ignorance. Yeah. All these fans of Sushant, they just go on wailing. Not one of them thought it fit to go and get hold of a lawyer and say, file a case against the Bombay police for not registering a FIR.
Absolutely.
Okay. So now, one last question. Supposing I don't want to go to the police. I want to file the case myself. I want to prosecute myself.
Yep.
Isn't there a provision in the Criminal Procedure Code, Section 200?
I don't know the section number, but there is a provision, and that requires you to go to the magistrate and present what is called a complaint, not an FIR, a complaint.
That's right. Complaint,
and the magistrate will then take cognizance of your complaint.
And issue a summons.
Yeah, exactly.
Yes, and then once they oblige the summons, then they take. This is what happened in the National Herald case.
Right.
I tried with our police. Mr. Jaitley wouldn't allow the FIR to be registered by the CBI. So finally, I went to a court and said, "I've detected a crime." And so I was heard. I was cross-examined. Evidence was brought on. Preliminary evidence.
Yep.
And the lady magistrate, she issued the summons.
Yep.
and then Sonia Gandhi, etc., had to come and take bail.
Yep.
And now the process of filing the charge sheet, that proceedings is on, in which I'm being cross-examined in the final. It's in the final stage, and after that, evidence will be led and charges will be framed. Then the trial starts. If there is no charges filed, they will be discharged. But I'm sure that charges will be framed.
Yeah.
Anyway, it's a fascinating thing to learn. I'm telling you, every student in school, the 10th class, 11th class, should be made to learn what is what is IPC, what is CRPC, and what is the law of evidence.
Yep. Absolutely.
What is evidence? You must know.
Yeah.
And the law of evidence is a thorough. It's very thorough. I don't think that I've seen a law of evidence like I've seen in India anywhere else in the world. And yet, such ignorance today of the law.
Yep.
That people are frightened if some policeman comes and rings the door.
Yeah.
Even someone dressed like a policeman, he can frighten you and collect some money and go.
Oh, yes. Absolutely.
So that's why you're doing a great human service by removing the illiteracy. It's like this.
As I said, I'm speaking on a subject on which I know next to nothing. So
no, you know the basics. And that's what we want.
Just about.
No, that's what you just need to do. But the fact that you speak about a matter outside the court in India would not attract any action from the court in normal terms. Yes, normal terms. That people sub judice.
Yeah.
You will hear it on television all the time. All these illiterates saying sub judice.
Crass ignorance, and I'm sorry to say that has spread even to the highest levels of the judiciary.
Yeah, I've heard ministers saying sub judice.
Yeah. Very sad.
Okay. Yes, Rajneesh.
I have a question on behalf of the viewers. Would like to know, corruption cases will be classified as criminal cases or civil cases?
Prevention of Corruption Act. It's a separate act.
Criminal case, and of course, now I don't know whether any civil suit has been brought, but in most countries it is also possible to proceed against the to seek damages against the person. But actually, on the prevention of corruption angle, which is purely criminal, Swamy will probably be able to tell more because he has been personally involved in quite a few of these cases.
No, there was an act first.
Personally involved not in the cases, but fighting the corruption cases.
Indeed.
Yeah, that's why
he's involved in a very pleasant way.
I'm putting it in a lighter way.
Yeah. Corruption case. The thing is that in 1947 we enacted a Prevention Corruption Act. Then Rajiv Gandhi's tenure in 1988 was again revised, and then again revised. And there was one provision which Mr. Jaitley, despite my fighting to tooth and nail to see that he doesn't succeed, he deleted, and it was a very powerful section. It was a section 13(1)(d), part 3. It says that if any public servant enables someone else to make money on a transaction, then the minister or the public servant is also liable for criminal prosecution under the Prevention of Corruption Act. That is, you see, one of the tricks which ministers were doing is they never accepted the money themselves. They got some underling to go and collect the money. So that was introduced during Rajiv Gandhi's time to enable a minister to be liable if he enabled anybody else to make money, even if he didn't make any money. I mean, he didn't make any money on paper. So, fortunately, by then I had filed the 2G case was already in advanced stage, and then Chidambaram, who could have used it to escape it, I had filed it by then. And Jaitley lost the race in trying to do it before I get to prosecute Chidambaram. So Chidambaram was bound by the old law.
What was attempted was an amendment to the Prevention of Corruption Act.
Yeah, to remove this particular thing.
I see.
By Parliament, yes. And it was removed.
Right.
But I just would have been removed before I went through with Chidambaram. But I put up such a fight.
Yes.
Ultimately, even the RSS had to be brought in to persuade me. Then finally, the Minister of State in the PMO, Jitendra Singh, he had a session with me, and then some wordings were corrected. So even now, I can bring it in, but in a roundabout way.
But also, presumably, when you brought those cases against those particular people, the section was still on the statute book.
That's right. So by time, because I got this delayed coming to Rajya Sabha and getting passed by one pretext or another. So I was able to prosecute Chidambaram and send him to jail. He spent 106 days in jail. After Jayalalitha and Sashikala, he's the next person I've actually sent to jail. And I said I would do it. So, but fortunately, because I put up this fight, and the party didn't want me to vote, I said I'll vote against it in Parliament. And then, people sat with me, and then the Jitendra Singh sat with me, and then we worked out some wording change, and then I said, okay, you can pass it. Although I can still do the same thing, but it is by a roundabout route, not the direct route.
So I have a question from a viewer.
Yes.
Are there any limitations of filing an FIR? I mean, that's a very generic question in terms of limit. I mean, timing is important. I mean, like what Dr. Swamy said, the SSR case, would the statute of limitations come into play? Because they've not filed an FIR at all so far.
Swamy, do you want to take it, or can I just give you a preliminary view?
Yeah, you give a first. You're the guest.
Okay. Without, as I said, knowing the detailed provisions of the law, what I would say is that I'll make 2 points. The first point is, incidentally, that an FIR does not have to be lodged by anyone connected with the incident. It could be a complete stranger who could go and file an FIR.
Yeah, I saw it on the road, some dead body there.
Yeah, that's one. Secondly, on the specific point that you're raising, I would imagine that if there is no statutory provision, then the view would be it has to be done as reasonably soon as possible. Reasonably, not necessarily, within 48 hours or 72 hours or something. But Swamy might have something to add.
No, I have a Supreme Court judgment, 2008. If you look at the latest volume of the printed volume of the Indian Penal Code, they have little small citations also given when they
annotation.
It specifically states, and I went to the original judgment, that upon receipt, without any delay, the first thing the police station has to do is to register. The only exception has been given to CBI, which is allowed to first file what is called as PE case, register a PE case called preliminary inquiry.
Yeah.
And after that, it can be converted to an FIR.
But I think
CBI is not under IPC.
Right, but I think Ramesh's question was different. Is there a limitation in terms of approaching the police to file an FIR? Is that what you're asking?
Yes, I would say more than 1 hour. You heard it, and 1 hour later you had still not filed. That's enough. But
Swamy, I think Ramesh is asking something else. If I understood him correctly, what happens if a person indefinitely delays giving the information to the police? Is that what you have in mind?
delays giving the information to police.
Yeah,
How
yeah.
would you find out? How would you find out? Okay, he
So
was.
I'll give an example. Suppose there was a murder, and
No,
the
he.
person
I
who,
don't think he said that. What he wanted.
No, I don't think. No, that's not Venkat. My question was
Yeah.
this. See, in terms of filing an FIR,
Yeah.
so the police, let's take SSR's case,
Yeah.
like what Dr. Swamy said. The police has still not filed an FIR. So who files it?
Okay, you're talking
So
about
does the
actually
complainant file
recording
it,
the
or does the
information.
police file it? Yeah.
Well, I'll say this.
Yeah.
First of all, this is an academic question now, because CBI has been given the charge of the investigation, and the court said that for an FIR you have what is, or there was some, the parents had filed something about Sushant's property had been looted or something. So there was an FIR on that. So he said this FIR you can use and expand. And in case the Bombay police decides to file a new FIR on the information it received, that will also automatically, after it is filed, will be transferred to the CBI. So I can dereliction of duty is still a possibility for Bombay.
Okay. That was leading where I was leading to. Basically, as of now, they have not filed.
Yeah. No, yeah. You can go to the High Court and say that this is a dereliction of duty. It has weakened the public confidence in the police, and therefore Bombay police should be prosecuted.
Actually, you can even put it at a different level and say it's a breach of statutory duty. As simple as that. Yeah. So, but Ramesh, sorry, I misunderstood your question. I thought, for example, if there was a death and the person who knew about the death did not inform the police, did not give information about the police. That's a different.
Yeah, but that is very difficult. Like,
yeah,
in the investigation, let's say, for example, they find out that he knew it, then they can probably go jump on board. Otherwise, people go silent in a lot of cases. They don't want to get involved, quote unquote. They don't want to get involved.
Yeah. Okay.
Okay.
Only I would like to make a remark, Dr. Swamy, like in Prevention of Corruption Act, you discovered in the 2G case that as a private individual, you can also be a public prosecutor, which most of the people, including the lawyers, did not know. Can you just tell us a little bit about it?
Yes, the provision is there under Section 301, and that if you bring a complaint, like in National Herald, I am a public prosecutor. I am taking the place of public prosecutor. I am prosecuting it. I am, of course, also a complainant, so I'll be cross-examined. And when I don't like a question, then I, as a lawyer, I tell the court, as an advocate for Dr. Swamy, I object to this question. You see, so there is a provision. That is why I am saying to the Indian people, and particularly the young educated people, don't be afraid, because the Indian law is so devised that you can you can become the de facto policeman. So unless the police thereafter files an FIR, then the police takes over. But not. For instance, in Sonia, in the Jayalalitha's case, I was prosecuting Jayalalitha. Then the DMK government came to power, and then naturally got jealous, like many of our politicians do. So he filed an FIR and backdated it. So that he had already filed an FIR. He need not have backdated it. Even if he had filed it and postdated the same thing, he would have got the Madras police would have taken it over. But then I was conveyed to Mr. Karunanidhi, I know that you have backdated it, and I have proof, and I'll file a case against you. So he pulled off, and then I continued the investigation. The investigation and the prosecution. And I argued in the Supreme Court also. High Court, Supreme Court, everywhere. I was de facto, without going to law college, I'm a lawyer. It's more difficult to be a doctor than a lawyer, but still. So
Okay.
okay.
Yeah. So with this, we come
Oh, we
to
have
an
taken a lot of extra time today.
today. With this, we come to the end of another interesting session of legal words of wisdom, Nyay Gyan Ganga on our Virat Hindustan Sangam social media channels. As you know, we are beaming this live on Facebook, on Twitter, Periscope, on Instagram, and YouTube. We have a regular Sunday program at 8 p.m. and tomorrow's Sunday program will be another interesting program, a little to do with law, in fact, a lot to do with law. Tomorrow's program is where Dr. Swamy will be the main speaker, will be was inclusion of socialists and secular words during the emergency in the preamble impermissible. We are going to be discussing this interesting topic tomorrow in our regular Gyan Ganga Words of Wisdom. So please be tuned in. I thank Dr. Venkat Iyer and Dr. Swamy for this interesting discussion on the criminal law system. And I thank my co-host Ramesh Swamy and also the technical team led by Ashish Shetty, Vishal Mehta, Rakesh, Tejas, Ishwar Iyer, Swaminathan for their inputs to put this program together. So with this, we end our program. We will see you tomorrow on our regular Sunday Gyan Ganga at 8 p.m. Indian time. And we will be again on Saturday, the next Saturday, we'll be having another interesting discussion, which is on the 5th of December, another interesting discussion on the legal words of wisdom, Nyaya Gyan Ganga. Thank you, everybody. Thank our viewers. And we'll see you tomorrow at 8 p.m. Indian Standard Time. Thank you. Dhanyavad and Jai Hind.